So we have been dealing with the law reform process. It's a very technical process. It has its language, its legislative language. You don't use layman terms to deal with that. 1 minute. Okay. So today, by way of revision, I want to start from the beginning so we can discuss. Now, yesterday, an interesting question arose. We have been talking about the difference between law review, law revision, law reform, consolidation, codification. Now, somebody asked me a question yesterday, and this is interesting. Can it be that a law reform agency, commission of any country, can it be that in a particular exercise, they are not just doing law revision, it includes law reform, it includes consolidation? Is it possible that a particular exercise could include that? And I said yes. Because when you started the project, for example, I was involved in, some years ago, I was involved in the age of criminal liability in Islamic states, Iran, as a case study. That was when I worked with the British Institute for International and Comparative Law. So we were looking at all the laws of Iran. What is the age of criminal liability? In some countries, it's 21. In some countries, it's 11. So we were looking at all the laws on criminal liability. Now, when we started the project, we are thinking of it as a law revision project. But in the course of looking at those laws, you may now discover that, look, you may need, what's it called, to reform some of those laws. Now, you know the difference between law revision and law reform. Law reform is the activity that needs to be submitted to the National Assembly or the legislature. Law revision, however, is different. You tidy up the law, you arrange it in an index and all that. So that one, law revision does not require the input of the legislature. Now, what if you start a project as a law revision project? You identify laws that need revision, and now you need to submit them to the legislature. Will you say because you're doing a law revision exercise, therefore, no, my hands are off? What do you think? Let's have a discussion. What do you think about that? You can unmute your mic and discuss. As you're reviewing the law, you now find that there are aspects of that law that even need constitutional alteration. So what will you do? Will you say, well, I'm dealing with law revision. I don't want to go before the parliament. What is your thinking? Please, I welcome comments. What is your thinking? Hello? Can anybody hear me? Please confirm that I can be heard.
Yes, you can hear you, sir.
All right. So you heard me. You started a law revision exercise. For those who are just joining, the difference between law revision and law reform is that law revision requires the final approval of the legislature, whether States House of Assembly or National Assembly. On the other hand, law revision, sorry, did I say law? Law reform requires the endorsement, the final approval of the legislature. They need to pass a bill to give effect to the laws that you have reformed. Law revision, on the other hand, does not require the input of the legislature. we say the difference is law reform occurs when you have touched the substance of the law. If you put a comma while reviewing the law, if you put a full stop, that means you have touched the substance of the law. Therefore, that is law reform. Therefore, that document needs to go back to the legislature for their approval. Whereas law revision does not, you do not touch the substance of the law. You can create a table of index for the laws without touching the law, the substance of the law. That is law revision. So we say if you start a law revision project, and in the course of your project, you find out that some of the laws require reform, some of the laws require constitution alteration. What are you going to do? Would you say, I am doing law revision, therefore I'm not going to touch on the law reform aspect, on the constitution alteration aspect? What will be what is the ideal thing to do, the professional thing to do? Yes, we welcome comments. We welcome comments. Remember, the purpose of this lecture is to improve from being mechanics to becoming automobile engineer. Yes, Oscar. Your two devices are near each other, Oscar. I think that's why the echo.
All right, Prof. So what I see there is that since I'm doing a review, and depending on the time I've been given to do that review, if it's something that can accommodate waiting for the house to now sign off on it, then I should think that I will have to pause and recommend those alterations that need to be added. Otherwise, if it's time bound, I think the best thing we just need to finish the review, and then whatever alterations that can be recommended, after that we probably redo the review again.
Okay, thank you for that thought. Who else has another thought? Yes, Tumelo.
Thank you very much, Prof. I think because of the complexity of both processes, it would be wise in principle to do one as per mandate, because if this one of reform, one may be engaging with the substance of the law, then it would be unwise of the legislative drafter to go beyond the scope of the mandate where they know that they have not of the process. Perhaps it would be wise to simply exclusively stick to the process that one is engaged in. Thank you, Prof.
Okay, that's another thought. Let's hear your comments. Let's hear your comments. Yes, Madam Shetak.
Good afternoon, Prof, and everyone. For me, I would think that I would prefer to do the law reform while doing the law review so that it is all encompassing. But like I think last speaker said, so as not to go outside what you were mandated to do, you do limit yourself to the scope of what you've been asked to do. But I think it will be good, as you notice that, you should also take it upon yourself to do the law reform. It might actually take longer since it entails more going to the house and everything. So if you can't do it within the time limit meant for the review, I think you should keep it in view so that once you're done with the review, you can go on with that process. But I don't think you should ignore it at all.
Good. That's another thought. Thank you for that. Any other thoughts? Any other thoughts? Now, I don't know about uh, the Kingdom of Lesotho. In Nigeria, there is a constitution alteration process. There is at the National Assembly, there are two committees. One is in the Senate, one is in the House of Reps. They are called Constitution Review Committee. So every 4 years, the Constitution is reviewed by this committee. So let us assume that a state government has an idea for alteration of the Constitution. You have to write to that committee. If you have proposal for creation of local government or creation of states, you have to write to those two committees. So just as what Madam Shetak said, if you're doing a law revision project and you hit a bump in the road where it says that part of the law can only be amended by the Constitution, that means there's nothing you can do. You only write to the appropriate authority seeking constitution alteration. And if you're a law reform agency and you are doing a revision exercise, let's say you're reviewing all the laws on children in Lesotho, when you get to a point where what you're doing is just consolidation, you're bringing together all the laws, identifying the ones that need amendments, the ones that need reform. Now, when you identify in those body of laws the ones that need amendments, the ones that need reform, it then means your duty as law reform, your present task as law revision cannot continue. You gather them, those ones that need amendments, list them, the sections that need amendment. You even can draft proposed amendments and then send them to the legislature. Send them to the legislature. You cannot just ignore them and say, no, what we are doing is strictly law revision. Because the opportunity to go back may not be there. And the funds, not just the opportunity, the funds to undertake another exercise may not be there. So when you get to that opportunity and you see that there are parts of the laws that need revision, it is your duty to call the attention of the legislature. You know the process. In Nigeria, since the Law Reform Commission is under the executive, the procedure is that the head of the Law Reform Commission would gather all those that need amendments, write a cover letter, submit them to the Attorney General. The Attorney General will submit it to the Federal Executive Council. If it's a state executive council, then the president or the governor will write a cover letter. It now goes as an executive bill to the legislature. That is the process in Nigeria. So as a lawyer working in law revision, law reform, you should know this process so that you advise properly. You follow the steps. As a law reform commission, you cannot write directly to the legislature. You have to go through your Attorney General and Minister of Justice to present the bill as an executive bill, seeking amendments of those sections. So that's the procedure. I don't know about the Kingdom of Lesotho, how they deal with that. But in Nigeria, that is the procedure. So has anyone been involved in law revision, law reform? Can you share your experience with us? Anybody? Anybody? Have you been involved in law revision or law reform? Yes, any? Hello? Hello? Is anybody hearing me? I hope.
I can hear you, Prof.
Right, all right. So the procedure, we have stated the procedure in Nigeria. The Nigerian Law Reform Commission is under the executive arm of government. Therefore, after they finish their processes, if there are parts of any law that requires amendments, which needs to go to the legislature. So anytime a law requires amendment, that means it's a law reform activity. The Nigerian Law Reform Commission would submit its proposal to the Minister of Justice, who is the head of supervisory head of the Nigerian Law Reform Commission. Then the minister will take it to the Federal Executive Council. At the state level, you have Commissioner of Justice. They are the ones who take those proposals from the Law Reform Commission, take it to the Federal or State Executive Council. There is a vote by members of the Federal Executive Council. Do you agree with this to go to the National Assembly or the legislature? When the votes are taken, the secretary to government writes the minutes that on so date, the Federal Executive or State Executive Council has approved this to go to the legislature. Then the president has to write a cover letter. It's a tradition. Every executive bill must have a cover letter from the president or the governor. In Lesotho, that should be the king or prime minister. Sorry, prime minister. But because you practice parliamentary system, the ministers will table this request in parliament. They don't need a cover letter from anybody. So that's the difference between the two. It's a traditional thing. Those of you who were here at the beginning, we said there are three kinds of bills that come to the legislature. One is called executive bill because it comes from the executive arm of government. The tradition is it must come with a cover letter from the president or the governor. No minister in Nigeria can send a bill directly to the legislature. The approval of the Federal Executive Council first, then second, a cover letter by the president or the governor, if it's a state. Then it goes to the parliament. Another kind of bill is called judiciary bill. Judiciary bill is a bill that emanates from the judiciary. And the tradition is that the chief judge must write the cover letter and send it to the legislature. A judge cannot send a bill to the legislature. The reason is judiciary bills arise when the judiciary sees that there's part of a law that has been problematic. They've given several judgments on that particular law. Then the chief judge will recommend amendment of that portion of the law. So the chief judge will write a cover letter, attach the judgment that is on that legislation and send it to the National Assembly or the State House of Assembly, as the case may be. That is judiciary bill. So executive bill, judiciary bill. Now the other bill is called private member bills. Private member bills means these are the bills sponsored by legislators who are members of the legislature. So they will draft their own bills. They will also submit it to the speaker or the president of the Senate, seeking approval to pass that bill into law. So three kinds of bills: executive bills, judiciary bills, private member bills. So, for example, the Law Reform Commission of Lesotho or Nigeria, if they notice that a particular law has been litigated upon too many times, they may recommend to the chief judge. Then the chief judge will do a cover letter, send that judgment to the legislature for them to amend that particular legislation. These are technical things that it's not every lawyer that has this technical knowledge. Of course, before the Law Reform Commission would make that recommendation to the chief judge, they would have followed through with the steps for law revision or law reform. They would hold their public hearings, invite stakeholders to talk about that aspect of the law, gather these inputs of the stakeholders, attach it with a proposed draft amendment, and send it to the chief judge. The chief judge will now write a cover letter and send it to the legislature. These are technical details, very technical. It's not everybody that knows how these things work. Okay, any questions? Any questions? Yes, Madam Oju.
Good afternoon, Prof.
Welcome.
Okay, my question is, can a private member initiate this process of law reform?
No. No. A private member can sponsor a bill, but the Law Reform Agency was created by law to handle this process. A private member cannot go and be doing public hearing, what's it called? There's a research before you even, there's something called law review. We said in part of our process. Law review is when you are scanning through your laws and identifying the ones that are problematic. So a private member does not know this law reform process. The best bet for a private member is to write to the Law Reform Agency and say, please help me. There's this law that I think needs revision, or this area of law needs revision. Please, law reform, please help me. And there's a process to instruct the Law Reform Commission. You can go online, get their form, fill the forms of what you want, or you could physically go there and inform the Law Reform Commission. Please, I need you to review or revise this area of law for me. Does that take care of your question?
Thank you, sir. Thank you, sir. But what of a state that has no law reform commission? What will be the procedure?
Okay, so it's under, usually the powers are embedded. If you check your, is the Attorney General's office. I worked as a consultant to Bayelsa State. They don't have a law reform commission. It was the Attorney General. Their law gives him power to revise the laws of Bayelsa. So we did as a committee. He set up a committee. We revised the laws, and they even got LexisNexis to publish their revised laws. So you have
Thank
to
you very much, sir.
look at the laws of the state. Another state I worked with as a consultant is Rivers State. They didn't even know that inside their law is a military decree that became a law, that there's provision for a law reform commission. They didn't even know. So the governor did not establish it. They were just going by what Attorney General says. So most times you need to look at, it was in the process I saw that Rivers State has 134 laws. There are laws on almost every subject. But even the lawyers at the Ministry of Justice did not take time to look at those laws. So they didn't even know that they have such laws. Sometimes they will go and draft new laws on subject matter that already exists inside their laws. So one needs to do a thorough job. You can't just be guessing. look at the laws, especially those states that were carved out of existing states. You have to look at the laws of the existing states and then the laws passed by your own state. I think Zamfara is having that problem. They were carved out of Sokoto states. They've not been keeping good records. So they don't even know the laws they have passed and the laws that exist. I'll share an experience. When you don't keep the statute books in good condition, when you don't have an index, you end up, the state legislature or the federal, you pass laws that have already been enacted. So for example, at the federal level, we have two ICPC laws. The first one was enacted in the year 2000. They forgot about it. They didn't establish the agency. They just passed the law because the United Nations was on our neck that we need an anti-corruption agency. So they passed it in the year 2000, took a copy to United Nations to show, oh, we have a law on anti-corruption. But they didn't establish the agency, so they forgot. In the year 2003, another ICPC law was passed by the National Assembly. So now we have two ICPC acts. And that tells you that the drafters did not do a thorough job. You remember when we said in your final provisions, you look through your index of laws of that country to make sure that if it affects an existing law, you repeal under repeals and consequential amendments, which are part of final provisions. So it shows that the drafters did not do a good job. They now passed another ICPC Act in the year 2003. So Nigeria has two anti-corruption laws. So that's a lesson for us that we need to do, and for those in law reform commissions, you need to do a thorough job. And then once a law is passed, you need to gazette it, because the gazette gives every law a number so that you can track and you do not repeat the mistake of enacting a similar law. So all what we have been teaching, learning, under law reform, gazetting, they are all interrelated. You cannot just do a reform on a law, then you do not do the final step of the process, which is gazette. The gazette is what gives you a number, a date, when this law was passed, when it comes into effect, so you can trace it, so that in the future you don't repeat the mistake of reenacting that same law. Okay, any questions? Any questions? We are being told the class will end in 15 minutes. So let's take this opportunity we have a tradition here to welcome new ones, and they need to introduce themselves to the platform by putting on their video and then telling us how they knew about this class. So Madam Sophia Canning, I'm seeing you for the first time. If you don't mind introducing yourself. Hello, Madam Sophia.
Yes, sir.
Please introduce yourself.
Good afternoon, sir.
Yes.
Kanen Dauda.
Okay.
I'm with the Plateau State Ministry of Justice.
Okay.
I was introduced to the platform by my director, Mrs. Shetak.
Okay.
I'm happy to be here.
Thank you for joining.
Yes, sir.
Okay. Now let's see. Is there another new person? Okay. I think. Even though, yes, Benjamin Amefule, you have to introduce yourself because we have participants from Lesotho. This is not the Nigerian class you attended. Hello, Mr. Benjamin Amefule. Please introduce yourself. Hello. Okay. While we're waiting for that, any questions? Anybody has any questions? Any other questions? Any questions? Okay, let's get your feedback so far with the lectures. How do you, is there any addition to knowledge by way of these lectures? Hello? Yes, Tumelo?
Thank you, Prof. Professor, these lectures have been a miracle. Honestly, they have brought so much insight, and also they have brought appreciation of some of the things we saw happen but were unaware of the technical implications. And I think I speak on behalf of a lot of us in here that in terms of just general awareness of the complexity of the field in which we are now trying to endeavor in has been overwhelming. I cannot underplay the tremendous resources that you are continually sharing with us to make sure that not just only through these lectures, but through other extensive reading, we are able to better understand this new field. So we are very indebted and very thankful, Professor, for the platform. It is indeed achieving its mandate. Thank you.
Thank you. We appreciate. So, yeah. Any other? Those who didn't join from the beginning, I said, as a young lawyer, it was during my national service. In Nigeria, you have to serve your country 1 year after graduation. So it was during my national service that I took an interest in legislative drafting. And the reason was simple. All the lawyers, we were posted to the Sokoto state, a northern state. We were told to, or we drafted a bill for the state legislature to enact. Unfortunately, or that was, we thought as lawyers, we were very young, proud that we know how to draft. We copied precedent, we drafted. We submitted it to the Attorney General of the state. He looked at it, he laughed because it was not well done. There was a major gap in that law. And he said, unless you cannot come by way of legislature, it had to be a constitution amendment. Although 20 years later, the Constitution of Nigeria was altered to allow state governments to own prisons. That was a major, as young lawyers, we drafted a law to enable the state government to deal with prisons, decongest prisons. The Attorney General then told us no, because in the Constitution then, only the federal government could deal with prisons. So it was not until 2023. Coincidentally, I was the one that drafted the bill for the Deputy Speaker to remove prisons from the federal laws, put them in the states where we call concurrent lists. I didn't even know that this was a coincidence. I drafted the bill to remove prisons from the exclusive list, which is for federal government, and is now in the concurrent list. So now, beginning from the year 2023, state governments can own and operate prisons in Nigeria. So it was that curiosity. How come none of us, 20 lawyers, young lawyers, we were busy drafting, we didn't even think about doing a research before you start drafting. So, Tumelo, you use the word, the technical details. This training is about technical knowledge. It's not just your regular law knowledge. There are technicalities. That's why we introduce you to the methods in legislative drafting. Taunton, for example, said, before you draft, there are 5 steps. The first steps, after you receive the drafting instruction, the next step is to analyze those instructions. Are they constitutionally correct? Are they correct from the point of view of the legal system, other laws, judgments on that subject matter? So you see that all this we're introducing you to gives you the tools, the technical tools. If they ask you to undertake a law reform or revision exercise, you know how to go about it. It's different from trial and error, which is what a mechanic does. But the technical knowledge that you now possess from these classes puts you at an advantage or at a higher pedestal than the mechanic. That's why we say in the process of this course, every lawyer can draft a bill. However, not every lawyer is a legislative drafting lawyer. So when you have elevated yourself from a mechanic to an automobile engineer. So all the notes, all these things we are presenting to you, if you keep them well, create a folder, just be keeping them there. You can email the folder to yourself. That's what I do. So that you don't misplace, your phone can get missing and those things go. Your computer can crash. But if you have it by way of email, you open your email, lecture notes on legislative drafting. Everything is there. All these things we post on the, the platform, you copy them, put them, email it to yourself. It never goes missing. So, and I will tell you from my experience why you should be emailing, apart from these lecture notes, even yourself, when you have a good idea, you want to write something, you email it to yourself. You know, email tells you the date it was sent. I'll tell you why. I had a funny experience. There's a man, when I was chairman of the Nigerian Copyright Commission, the Director General who I was supervising, he sent a book to me to review. But before then, months before, or even a year before, I had sent him a book for him to look at the book I wrote on the same subject matter, copyrights in Nigeria. Then he read my book, he gave me tips or whatever. This happened maybe a year. Then he also wrote a book on the same subject matter. Now, when he was arrested or for embezzlement, in the bid to free himself, he came up with the idea that he's going to accuse Dr. Jaja that I plagiarized his book. You know what saved me? I just went to the email, printed the email to show that my book was earlier than his book. So who do you think would plagiarize a book that was published 2023 and a book that was published for the first time 2025? Who amongst the two plagiarized each other? So people could tell that he was just being mischievous. So when you send yourself email, your ideas, always send them as an email to yourself because it has a time, a date. So that if anybody, there's a contest, who had this idea first, the date you emailed yourself, it will show you as the owner of that idea. I have dealt with cases. There's a legislator in Delta State. No, it's Edo State. Do you know that he was suspended because he accused the speaker of plagiarizing his bill? And really, that's what happened. He submitted the bill to the clerk as a private member bill, on, let's say, 1st of March. So what the process is, you submit to the legislature, the clerk. The clerk will give you a date for first hearing. The man waited and waited. He never got a date for first hearing. Only for months later, the same bill, word for word, is now being sponsored by the Speaker of the legislature. The man raised alarm, plagiarism. As an NGO, we took up his case and we saw that the date, good thing he emailed it to the clerk. He didn't send it by hard copy. So there's a trail of the date he sent it to this clerk. So that means he came first before the Speaker. That means he's the owner of that bill, the copyright. Very important. Always try and email yourself documents, even your own documents. Email it so that you know the dates, so that if there's any dispute, you would be in a better place. So on that note, we have come to the end of today's lecture, but if you have any questions for the remaining minutes, you can ask. Any question? Yes, Umaru, Hannah.
All right, sir. Good afternoon, Prof. Good afternoon, everyone. So my question is on the law review and law reform. I'm just curious to know if it necessarily have to go through the committee stage. I'm sorry, sir, the first reading, second reading, those stages. If it necessarily have to, since it's not like a bill emanating from a private member, does it really have to go through that procedure before it is being enacted as a bill? That's my question.
Yes, yes. The procedure is that when the Law Reform Commission finishes a job, it gives it to the Minister of Justice or the Commissioner of Justice. A cover letter is written and submitted to the legislature. Then the legislature will start first reading, second reading. It goes through the same process.
Recording in progress.
All right, thank you, sir.
Thank you. So on the, that's where we can go. This is how far we can go. Any question?
How can the legal profession, particularly law firms and by extension the MBA, create a more conducive environment for lawyers?
Okay, so on that note, this call is about to end. So we'll continue tomorrow. Thank you.